Hi there, I'm Jim Zirin. Welcome back for more Conversations. When Justice Antonin Scalia died unexpectedly in February of 2016, his obituaries uniformly remembered him as a great conservative judge, the intellectual leader of the conservative wing on the Supreme Court. What is not commonly known or appreciated is that Scalia, while undoubtedly a conservative, was the author of a number of strikingly liberal opinions. With us is David Dorsen, a distinguished lawyer and legal biographer who was also a friend of Justice Scalia. David Dorsen is author of a monumental biography of Henry Friendly, the greatest federal judge of his era, and has a new book out with the surprising title, The Unexpected Scalia, a conservative justice's liberal opinions. And he's here to tell us about it. David, welcome.
Thank you very much, Jim.
Now, you had a close relationship with Justice Scalia. Are you able to tell us something about it?
Sure. We got to know each other a little bit in law school. I was on the Harvard Law Review in my third year, and Justice Scalia was a year behind, so we spent 1 year together and became acquaintances. And then we got together a few times over the years. And then at one point, actually Stephen Breyer suggested that why don't Justice Scalia and I get together, and I should call him. I did. His wife and he came over. And that started a pattern so that we saw each other quite a bit, usually 4 of us at my house.
Did you find you agreed with him on most issues?
I see you're smiling, and justifiably so. Absolutely not. I'm a very liberal, an atheist, and he, of course, is neither of those and very conservative in his personal thinking.
Now, there's an endless debate that goes on as to whether judges make the law, whether they legislate, or whether they find the laws, or the law's some brooding omnipresence up in the sky that the judge discovers. Which was Scalia's approach?
Well, he purported to be, I guess, a brooding omnipresence because he traced everything back to the period around 1790 and tried to, he said, conform the present law to what it would have been in that era. But there was a lot of invention and circumlocution involved, and my feeling is that he was not terribly successful. But his conscientiousness, in one sense, led him to write a lot of liberal opinions.
Well, he's an enormously productive judge. In 30 years on the court, he wrote some 900 opinions, including dissents. His dissents particularly were laced with sarcasm, particularly directed at his colleagues. Satire, humor. He talked about other judges' opinions as jiggery pokery or pure applesauce.
Right.
And was he like that personally?
Well, he was. We used to argue a lot, not all the time, because usually it was with our wives, and we talked about a lot of other things, including food, horse racing, opera, and all sorts of things. But we got into the law. He could be very tough and sort of nasty at times, and I try to return in kind, but he had the big advantage. He was on the Supreme Court, and I certainly wasn't.
Well, not that you're not an intellectual giant, but he certainly was.
He certainly was.
Even if his emphasis was somewhat misplaced.
I agree with you completely, yes. He was. In fact, he created, in a sense, the modern originalism, which initially under Robert Bork and others was trying to ascertain the intention of the drafters of the Constitution. And Scalia said the unexpressed intention of somebody is worthless. So he converted it to the ordinary meaning or perceived meaning of the text of the Constitution as it existed in 1789, 91, and later for other amendments.
So the understanding of the society at the time.
Exactly.
Now, many of his critics said that was pure applesauce because it was just an intellectual tool for driving him to a conservative result because he was a dyed-in-the-woods wool conservative.
Yes.
Do you agree with that analysis?
To some extent. He was a dyed-in-the-wool conservative. But he thought he could do what I think is impossible, namely to ascertain that there was a consensus and what the consensus was concerning statutes, or not statutes, but provisions of the Constitution and amendments, such as the Confrontation Clause, Interstate Commerce Clause. And I just felt that was hopeless. For one thing, society as it then existed was totally different. It was much more communal, much less individualistic. It was a static society. And an effort to do that under the best of circumstances was, in my opinion, doomed. What made it even harder was his assumption that there would be a consensus, and there was no consensus. Something like whether the president could fire a cabinet member, whether there could be a national bank. Those weren't resolved in the minds of the founders and framers, and you had a society that varied much, much more internally than ours. There was agricultural versus urban. There was slave versus free. There were all sorts of differences in society that made it really impossible to find a meaningful consensus.
Like 5 of his colleagues in at least the last 7 years that he was on the court, he was a devout Roman Catholic.
Yes.
Did you discuss theological questions with him?
Oh, absolutely. We even discussed what was more important to theology, Catholic theology, heaven or hell. And
he believed in hell. He said he believed in the devil.
He did, and in fact, he said hell was more important to the internal consistency and requirements of Catholicism than heaven.
I remember in the argument of the gay marriage case, you probably recall it too, a man stood up in the chamber and began to scream and yell, and so the marshals dragged him out of the room. And as he was being dragged out of the room, the man screamed at the top of his lungs, "You're all going to roast in hell for this." And Scalia said, "You know, I find that rather refreshing."
Well, he could say things like that, and he could get away with it. And I've been to a couple of arguments since he died, and it's not the same thing. I mean, it's not only what he said, but the fact that everyone was worried what he would say next.
Now, the alternative to originalism is probably a principle you at least partially ascribe to, and that's the living constitution.
Yes.
That the meaning has to change over time and take into account new technologies, new values in society, economic trends, and all the rest. He rejected that completely. He used to say, living constitution, it's dead, dead, dead. Later he said, he didn't mean dead, he meant enduring. So did you ever have that debate with him?
Yes, we did, and I must say, it didn't produce much light, but
a lot of heat.
A lot of heat, and what made the conversations much more enjoyable was that we were usually drinking some very good wine when we engaged in them. But the idea that you could have a constitution like the Interstate Commerce Clause that made a conservative, narrow application of it made sense 240 years ago, but it makes no sense now. And why? It's like keeping baby clothes on an adult. It just doesn't work, and there's no reason for doing it.
Well, his argument always was that people like you would like the Constitution to mean what you would like it to mean. And it's fine because you, David Dorsen, are an enlightened liberal intellectual, but suppose a bunch of fascists get on the court and they would like it to mean something else. So the Constitution becomes completely untethered to its text, its original understanding.
Well, I think he had a point there, but keep in mind that there are precedents, and
precedents. So he followed what lawyers call stare decisis.
Yes, he tended to do that, unlike Clarence Thomas.
Yes.
And he accepted a number of liberal principles or precedents, such as the incorporation of the Bill of Rights for states into the for states as
well,
opposed
he
to federal government.
said he disagreed with it, but he wasn't going to reinvent the wheel.
Exactly. And I think an originalist can be just as inventive and destructive, even more so, than a judge who follows precedent. And living constitution doesn't throw out precedent. It tries to build on precedent. And I think that's a much more constructive and realistic way of having a constitution and enforcing a constitution than try to recreate a society that no longer exists and no one understands. One of the things that makes originalism less stable is that it rejects precedent. Clarence Thomas was much more an originalist than Scalia, and he was prepared to throw out everything in the interests of originalism, and given the problems of finding out what the understanding was for a problem like a GPS, how do you decide what the framers would have thought of a GPS system on a car?
Well, I remember that oral argument involving the video games.
Yes.
Where he asked some question, Scalia asked some question, and the lawyer seemed not to understand it, and Alito interrupted and said, what Justice Scalia wants to know is what James Madison would have thought of video games. And Scalia snarled and he said, what Justice Scalia wants to know is what James Madison would have thought of violence. And so,
well, I think that highlights that.
Yeah, he believed that certain values which existed at the time are enduring values and would find their application.
Well, the problem was what I may think what the values at the time are different from what Scalia thought. So I think it ends up being just as subjective as the so-called living Constitution, and much less satisfactory, at least from my standpoint.
Well, let's take capital punishment, because he was a staunch advocate of capital punishment. Yes. He said he believed in it. He believed in it not only from the standpoint of the Constitution, but he said that it was informed by his religious belief. You remember he said that St. Paul had said, vengeance is mine, saith the Lord. And Scalia, well, who's the state except the Lord? And they're exercising vengeance. And then he pointed to the two provisions of the Fifth Amendment that appeared to authorize capital punishment. And then he said, as to the cruel and unusual punishments clause, that has no application, because at the time of the Constitution, we hanged people for horse stealing, and we threw people in the stocks for kissing their wives on Sunday, and it would be constitutional if there was a law prohibiting it now, but it would be stupid, but it would be constitutional.
Well, of course, one thing to keep in mind is that the Catholic Church is against capital punishment.
Well, that was later.
It was later, but it's still...
And when the Pope came out against it, he said, well, he's not speaking ex cathedra. He said it's just an encyclical, so I'm obliged as a Catholic to consider it. I've considered it, and I reject it.
That's true, but he was not blindly pro-Catholic, although he was generally...
He attended a church named after the patron saint of unborn children. Yeah.
But again, there are all sorts of debates about that, the cruel and unusual punishment. But why should we be cast in the mold of dealing with barbaric conduct? Branding and whipping and things like that. It makes no sense that we want to be a country that endorses and furthers the practice of branding and crushing thumbs and things like that. And there are arguments that you can make to avoid the argument which you just made cogently, that is the Fifth Amendment mentions capital punishment, and one is that capital punishment existed, so a constitution would have to deal with it. It was just taking things as it was then, without putting an imprimatur on keeping it that way. You can't ignore the fact that it was capital punishment, and how do you deal with it?
Well, Chief Justice Warren put it this way, that there has to be an evolving standard of decency which marks the progress of a maturing society.
Exactly.
And Scalia's answer to that was, I don't know what an evolving standard of decency is, and I don't want to know.
Well, that's right. I mean, he was not that flexible, I may add. I don't know that I ever succeeded in changing his mind. The closest I came to try to change his mind when I just said to him, but what about mercy? What about mercy? Think about these poor people who make one mistake. What about mercy? And he just said, it's the Constitution. It's not my personal beliefs.
Now, we hear a lot about liberals and conservatives on the court.
Yes.
And I find it impossible to define what is a liberal and what is a conservative, except the most obvious terms, that the liberals all seem to be appointed by Democratic presidents and the conservatives by Republican presidents. But how would you define the difference?
Well, that was a major subject and occupies the first few pages of my book. And ultimately, you start looking at what liberalism meant in England in the 17th or 18th century, what liberalism meant later, and I ultimately said the only thing that's really relevant is what we consider liberal now, and I could not find, and I couldn't find anyone else who stated a coherent approach to liberalism. So what I did was I took a number of propositions, like favoring the defendant, pro-choice, government expansion of welfare, things like that, and just made a list, and with rare exception, they fit into what the current conception of liberalism is. Every once in a while there was a conflict, rarely, but one I could give you is, how do you deal with the rights of a white-collar defendant? Scalia was very generous to white-collar defendants, and he was generally liberal in his treatment of criminal defendants. But that is quite different than...
So he could get them off or reduce their sentence.
Exactly.
Reverse and remand for further proceedings.
Well, he was more liberal than people like Thurgood Marshall and things like that, who were not terribly sympathetic to white-collar criminals.
Well, their argument is we're tough as hell on crimes of violence and drug crimes, so why are we lenient toward white-collar defendants who break a different law?
Well, I mean, there are all sorts of ways of rationalizing it. I'm not sure that there's a coherent philosophy either. It's just interesting that Scalia would probably have rated much, much higher than non-originalists, liberals, in granting rights to white-collar criminals. It just shows them the complexity of the problem that I had to confront.
Let's just get back for a minute to stare decisis, a fancy lawyer's term for standing by your decisions and adhering to precedent. Scalia seemed to adhere to precedent, but then he said if the precedent was malicious, like Roe v. Wade, or gay rights, then he wouldn't adhere to it. So he really was not so much of a judge who followed precedent as it might seem at first glance.
Well, because as he said in another context, I'm not a nut. And you can't just...
Said I'm an originalist, but I'm not a nut.
Yeah. So he accepted that certain things are very, very well settled. So this gives him flexibility. How do you decide whether something is well settled? And he made up his own mind. Similarly, sometimes there's a division between one prong of Scalia's philosophy, namely originalism, and another prong, which is textualism. And he could sometimes choose between those two.
You have a subtitle for your book, which is a Conservative Justice's Liberal Opinions.
Right.
And you could have written a book that went after his conservative opinions. It would have been a much thicker book than the one you produced. Why did you, are you a contrarian? Why did you go after his liberal opinion?
Well, because first of all, I'm a liberal, and it was more
take
fun.
Solace in the fact that this
well, he's a friend, you know. You have to,
iconic jurist had a liberal streak.
That's right, and I also wanted to. I thought I could sort of poke him a few times, and I succeeded.
Jiggery pokering him.
That's right. So the point was, I also think that the test of consistency for someone like Scalia or Thomas or Alito or the liberals is how do they react when their approach leads to results that they do not personally like. And I found that by and large, Scalia took his philosophy, which was essentially conservative, and followed it even when it took him to liberal waters. So that, to me, that was the test. I mean, you know, anyone can be conservative 100% of the time or liberal 100% of the time. That only means, to me, that you have no coherent philosophy. Well, and while Scalia was uneven and sometimes selective and sometimes contradictory, he was very liberal in things like the Confrontation Clause, search and seizure.
Was it liberal? Let's just examine the Confrontation
Yes.
Clause, because we keep coming back to that.
Yes.
There was a statute, I think, in Maryland that in a child abuse case, the victim did not have to be confronted with the molester, but could testify on closed-circuit television, so the victim wouldn't be traumatized. Usually it was a child.
Yes, almost always. It was a child. It related to children.
And
yes.
there was a statute that permitted that. And Scalia, fortunately only in dissent, objected to that because she said that virtual confrontation is not confrontation,
That's
and
right.
that was consistent with other cases he decided. So is that really a liberal outcome? Or?
Well, he said, what is confrontation? What does that mean? And for one, and he, as I said, as you said, he took a liberal position. But you can look at the confrontation clause in two ways. What does confront mean? Or what was the practice with regarding witnesses in 1791? And they could be totally different, just like Justice Hugo Black decided that Congress shall make law, no law respecting freedom of speech.
He said no law means no law.
No law, even though there were exceptions to libel, shouting fire, and a few other things. So, but Scalia then took the word confront, and it meant foreheads and other terms and uses, and decided it meant face-to-face without anything in between. That's textualism, and that's another example of what I was saying before about the fluidity of Scalia's philosophy. He didn't ask exactly what the practice was in courtrooms back in 1791, and in fact I get into it in my book as I do a number of these areas that he did not touch, and found it was actually more restrictive than Scalia was, that there was a whole different concept. There was another factor, aside from the fact that society was different, and that is the methodology for ascertaining the truth then was not cross-examination, it was the oath. So that the whole idea of
By then you mean 1789,
That's right.
1791.
And certainly earlier. So that, what does confront mean? Scalia quotes Shakespeare, and I quoted Shakespeare, I think it was Richard II or III, where he said, face to face I shall hear your account and I will decide. Well, all that meant, there was nothing about cross-examination. The point was the king, the sovereign, could impose an oath and get at the truth that way. And then this was an outgrowth.
Or possibly torture the truth.
Exactly.
Or
throwing somebody in water.
Until they confess.
No. If he sank, he was telling you the truth.
Yeah.
And if he floated, it was because the devil was saving him, and then they executed him. I mean, it was barbaric.
Scalia believed in the devil.
That's right.
Now, it's interesting. Was Scalia, in your view, a partisan judge? He made the statement that judges have been known from time to time to be partisan. Ruth Bader Ginsburg said, oh, the worst thing that could happen is if we were thought of as being partisan. Roberts takes the same view.
Right.
We can't be, just recently said, we can't be viewed as a Republican court or a Democratic court. It'll erode public confidence in our judgments.
Well, sometimes it's hard to tell whether it's partisan or philosophy. The best example of partisanship is Bush v. Gore, where...
I was going to ask you about Bush v. Gore.
Yeah, Scalia did not write an opinion, but he participated with the most...
Cast a decisive vote.
Cast a decisive vote in favor of Bush. And I just don't think that's a reasoned opinion or a valid opinion.
And what about Citizens United, where he also cast a decisive vote?
Well, that's a little different. There he was taking the position essentially that freedom of speech trumps everything. And you just cannot have limitations.
Is speech contributing money to a political campaign? Was
Well, he found look.
Was there any evidence that the society in 1791 thought that campaign contributions was speech?
I'm not sure they had campaign contributions.
That's the point.
That's the point, right? Exactly. But I think the idea that facilitating speech is one of the concepts he developed. And I think it's, when you start comparing it, say, to the Federalist Papers, and seeing that the Federalist Papers valued, debunked factions and wanted, there was an equality of access, I think the Citizens United was totally antithetical to certainly the spirit of the Federalist Papers and against the concept of corporation as it was understood in 1790, where it was virtually nothing and despised.
Well, we are winding down, so I really have two questions for you. What is next for David Dorsen?
Okay.
Premier lawyer who became a writer of nonfiction and now is going to write
A book called Moses v. Trump,
Moses
a novel.
v. Trump. Not two fictional characters.
No,
There was a Moses and there is a Trump.
Well, that's right. In fact, there's no fictional character in this book. There is a Trump who tweeted calling a lawyer a crook for fixing a case, a criminal case, and the lawyer was Ira Moses.
Ira Moses.
So it's Moses v. Trump, and it goes into all the contortions of a novel, courtroom drama, and the like.
And my second question is that Neil Gorsuch, who replaced Scalia on the court, and during the campaign, Trump said he wanted to appoint someone in the mold of Antonin Scalia. Mike Pence said the same thing.
Right.
Is Neil Gorsuch going to be another Scalia, or is he different?
I think he's more conservative.
More conservative than
As far as I
Scalia.
could tell, although I think the jury is still out on that. I think the jury is still out on that because there was a hint that he was moving slightly liberal in some criminal cases, as Scalia was. And I think the statement of Trump and Pence really showed the misunderstanding about the jurisprudence of Scalia, which I try to cure.
Which you try to cure. This has just been marvelous.
Oh, thank you very
David
much.
Dorsen, thank you for
My
coming
pleasure.
by.
My pleasure.
And thank you for coming by. This has really been terrific. Tune in next week for more conversations. I'm Jim Zirin. Take care and all the best.